Here is the second lecture on the Code of Civil Procedure 1908. Today's topic: Concept of lawsuit, essentials of suit, stages of suit. Lawsuit. Generally, section 26 to 35B and orders 1 to 20 of the first schedule deal with the procedure relating to suits. Orders 1, 2 and 4 provide for parties to suit, frame of the suit and institution of the suit. Meaning of suit. The term suit has not been defined in the code. Suit is a term of comprehensive signification referring to any proceeding by one person or the person against another or others in a court of law. Here, the plaintiff pursues the remedy which the law offers him for the redress of any injury or the enforcement of a right. Ordinarily, a suit is a civil proceeding instituted by the presentation of a plaintiff. Here is the essential. There are 4 essentials of a suit. One is opposing party. In every suit, there must be at least one plaintiff and one defendant. There may be more than one plaintiff and more than one defendant. But in the absence of either plaintiff or defendant, the suit cannot be instituted. Coming to the second essential. Subject matter in dispute. The subject matter in dispute of a suit is the right or property claimed by the plaintiff in the suit. The court adjudicates upon the right of the parties with regard to the subject matter in dispute. Cause of action. Every suit must have a cause of action. The cause of action means every fact that traversed it would be necessary for the plaintiff to prove in order to support his right to the judgment of the court. Coming to the fourth essential, the relief claimed. The relief claimed. Every suit must contain the relief claimed by the plaintiff. The relief claimed should be stated specifically in the plaint. When a person is entitled to more than one relief in respect of the same cause of action, he must sue for all the reliefs. However, he may sue for one or more of the reliefs available to him with the permission of the court. In case no such permission is obtained, he will be precluded from bringing any fresh suit or any reliefs he has omitted. Coming to the stages of lawsuit. Institution of a suit, service of summons, written statement, discovery, first hearing and striking of issues, production of evidence and argument, judgment, decree, and last one is execution. Coming to the institution of a suit. Every plaintiff should institute a lawsuit by presenting a plaint to the competent court. When the plaint has been presented to a proper court mentioning the cause of action, the relief claimed, and it is properly valued and sufficiently stamped and is not barred by time or any other law, the court admits the plaint and it is numbered and registered as a suit. Service of summons. After the registration of a suit, the court should serve a summons on the defendant or defendants who appears and answers the claims of the plaintiff. The plaintiff has to take the necessary steps for the service of summons. The summons has to be served in the prescribed manner with all requirements. Written statement. After receiving the summons from the court, the defendant may, at or before the first hearing or within such time as the court permits as per the statute, present a written statement of his defense dealing with each allegation made in the plaint and clearly stating that which of the allegations are admitted or denied. I repeat, with the present of a written statement of his defense means defendant's defense dealing with each allegations made in the plaint and clearly stating that which of the allegations are admitted or denied. Discovery. Every party to a suit is entitled to know the nature of the opponent's case so that he may know what he has to meet. The main object of the discovery is to secure, if possible, an admission of facts with the help of proof. The discovery is to be generally made by way of interrogatories served on the opponent or by requiring him to disclose the document by affidavit. First hearing and striking of issues. On the day fixed in the summons for the defendant to appear and answer, the suit is heard if both the parties are present unless the court adjourns it to a later date, and after perusing the pleading of the parties, answers to the interrogatories, if any, the court frames issues which have to be determined for deciding the case. If neither party appears when the suit is called on for hearing, the court may dismiss the suit, and if the plaintiff appears and the defendant does not appear, the court may proceed ex parte on the plaintiff's proving his case if the defendant is served with summons. When the defendant appears and the plaintiff does not appear, the court may dismiss the suit unless the defendant admits the claim. At the first hearing of the case, when both the parties are present, the court goes through the plaint, the written statement, and answers to interrogatories, and then examines the parties and records their admissions and denials. On ascertainment, the court strikes issues that have to be determined to dispose of the case. If it is found that the parties are not at issue on any question of law or fact, the court delivers the judgment at this stage itself. Production of evidence and argument. After framing of the issues, as generally in the case, a date is fixed for the final hearing when the party having the right to begin states his case and produces his evidence in support of the issues, and thereafter the other party states his case, produces his evidence and addresses the court on the whole case. After the evidence of both the parties is over, the arguments advanced on their behalf are to be heard by the court. Coming to the judgment. After the case has been heard, the court may pronounce judgment at once, or it may reserve its judgment and deliver the same on any future date. Due notice will be given to the parties or their pleaders. Decree and execution of a decree. After the judgment is pronounced, a decree shall follow, that is, a decree be prepared in accordance with the judgment containing the date of the judgment. Execution is the final stage of a suit. The execution means by which a decree or order of a court is implemented. The successful party can make an application in writing to the executing court specifying the mode of execution legally available to him, and thereafter the execution proceedings are commenced for the fulfillment of the decree.